Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another sentencing live stream with me, Grizzly K. This is Grizzly True Crime. Let's put my logo up there. Thank you so much all for being here. We are going to watch the Eva Benefield sentencing. We watched this entire trial together. We did a lot of trial prep as well. And it's actually taken quite some time to get here. So let me give you a quick recap. Eva Benefield was found guilty of manslaughter. So she was initially charged with the second-degree murder of her husband, Wes Benefield. And so she shot her husband during a domestic argument in 2020. And sentencing was delayed because her defense attorney wanted to interview jurors and all sorts of things. There were lots of motions filed, obviously a motion for a new trial and all of that. He's a very determined defense attorney. So Benefield was found guilty on July 30th. It feels like yesterday, doesn't it? Oh my word. Okay, so July 30th, after a jury deliberated for several hours, the 32-year-old former ballerina was accused of second-degree murder for the shooting death of Wes Benefield. And that happened on September 27th of 2020, but the jury found her guilty on a lesser charge, which was manslaughter. However, there's that aggravated factor of using a deadly weapon, so she faces a maximum of 30 years in prison. So let's see what happens. Now, if you're wondering why I say another sentencing hearing with me, live stream, right? Yesterday, we did a double live stream for sentencing. Sarah Boone was sentenced, and so was Jamie Komorowski. So if you missed those, please check those out as well. All right, so I've got a picture, as always, of the victim, Wes Benefield, up here. And so now we're gonna bring up the court feed, and we're gonna watch this together. We are on an intentional delay, so please don't come in here and try to be uncool and give us spoilers. We don't want spoilers, okay? Because we want to watch it together now. This is in case there was, if there's delays or fluff, and there was like they were half an hour late. So see, we're only gonna be like half an hour behind or so now. So I think that's great, right? Okay, so here we go. Let me put on the sound. I've boosted it for you as well. Here's Eva, Doug's daughter, sitting in the courtroom as well. I wonder if she'll make a statement too, right? Okay, let's have a look. So you could see her there. And then they bring Ashley in. Here we go. There's Eva Benefield. She was in one of the jails that actually didn't evacuate during the hurricane recently.
Case 2020 CF 3014, State versus Eva Benefield. Ms. Benefield is here present in court along with her attorneys, Mr. Taylor and Mr. Pinnell. Present for the state is Ms. O'Donnell and Ms. Friel. Ms. Benefield was found guilty by the jury on July 30th, 2024 of manslaughter with a weapon. It's a lesser included offense of the original charge, and it's a felony of the second degree. The jury did make factual findings of actual possession of a firearm, discharge of a firearm, and causation of death or serious bodily injury with a firearm. As a result, the statutory maximum becomes 30 years. Let me go over what I've reviewed in anticipation of sentencing, and then the state and defense could tell me if there's anything that I was supposed to get and review that I have not.
Oh my word, she's really looking rough. She looks so tired. Like she hasn't had a wink of sleep at all, right? I mean, given the circumstance, it makes sense. I'm just like, whoa, okay.
I reviewed the information in the file as well as the verdict form. I reviewed a score sheet that I believe was provided as a part of the sentencing memo. I don't have the original from the state. If you could hand that up. I reviewed the pre-sentence investigation, and Mr. Taylor, I know in your sentencing memo you had referenced various mistakes and inaccuracies throughout your presentation. If you want to point those out and what you disagree with, please feel free to do so. I've also reviewed the court file to watch the progress of the case and the events that have occurred. I did review the defendant's sentencing memorandum and the attachments, including case law, letters, and emails. All right, Mr. Taylor, have you had sufficient time to prepare, and are you ready to go this morning?
Yes.
All right. State, have you had sufficient time to prepare, and are you ready to go this morning?
Yes.
So the score sheet that's been handed up appears to be the same one that was attached to the defendant's sentence memorandum. It's got manslaughter with a weapon. That's a level 8 offense, 74 points. The victim injury points are scored at 120. Total sentence points of 194. Once you put through the sentence computation, gives the lowest permissible prison sentence of 124.5 months in Florida State Prison. Any objections to the score sheet?
No, sir.
So I know this defense, you received the PSI because you had mentioned it in your sentencing memo. State, did you get a copy of it?
I did.
All right. Same as I told Mr. Taylor, if there's any objections, additions, corrections, deletions that you want to mention, please feel free to do so throughout your presentation today. So how I do these sentencings, whenever I have an open plea or if it's a sentencing after trial and the defense is going to seek a downward departure, I generally start with the defense, presentation of evidence, then I go to the state, and then I come back to the defense, just because you carry the evidentiary burden. I'm sure you've discussed this with Ms. Benefield, but just so I have it on the record, Ms. Benefield, today throughout this sentencing hearing, you and your attorneys are going to be arguing for what we call a downward departure. And that is where you're going to be asking the court to go below the bottom of the guidelines or the lowest permissible sentence of 124.5 months. In order to do that, there's an evidentiary burden on the defense, and that is to prove by preponderance of the competent and substantial evidence that, one, you qualify for a downward departure, and two, that it's the most appropriate sentencing option and that the court should exercise its discretion to do so. So because you carry that evidentiary burden, that's why I generally start with the defense, then go to the state, and then come back to the defense. It's maybe the same or different as other judges do it, but if you want to do that, that's how I normally do it. If you prefer to do it the traditional way, I'll do it that way. Mr. Taylor?
I'm fine proceeding as the court suggests.
All right, sir. And then, of course, the opening statements and closing arguments are all the same. All right.
Yes, sir. I assume we will handle the departure aspect first, and then I will go into my closing.
Absolutely. Before we get started, I would imagine that there's going to be a number of folks who are going to make statements today either pursuant to Marcy's Law or victim impact. And certainly this is not a capital case, but as if you've done a sentencing in front of me, you know that I generally follow the dictates of 921-141 and 921-143 on what's appropriate and permissible as the scope and nature of victim impact statements. State, have you had a chance to speak with the folks who are going to talk today and let them know that information?
Yes.
All right. And I don't know, Mr. Taylor, if how many people are going to speak today, or if anybody's going to speak. Certainly I received the stack of letters as part of the sentencing memo. If anybody's going to speak today, were you able to speak with them about the nature and scope of a statement to be made?
We're only going to have one witness, Your Honor, and it goes to the departure.
All right. Fair enough.
Okay, so they're talking about a downward departure, and when I ask Google, Uncle Google, what is that? A downward departure sentence allows a judge to impose a sentence that is less than what Florida law requires in some circumstances. There are no automatic criteria that guarantee you a downward departure. Also, Ashley Benefield, she could face up to 30. When I say 30 in my South African accent, everyone thinks I say 50. I just get all the comments, it's not 50, 30. I'll say it the American way, 30. Okay, she could face up to 30 years in prison. Manslaughter with a firearm carries a minimum mandatory of 11.5 years. So she could get between 11.5 and 30 years in prison if the jury had convicted her on the second-degree murder charge, she could have faced life in prison, which obviously, as we know, in Florida, is like life is like, whoa, LWOP, right? Oh, my word. Okay, so Candy Jones said, no, upward only. Downward departure, you're like, no, only upward. Okay, so let's keep going.
All right, with that said, Mr. Taylor, would you like to make any sort of opening statement? Or I'm going to address you mostly, Mr. Taylor, but if Mr. Pinnell, if you're handling part of it, please feel free to let me know. Or would you like to make any sort of opening?
Not necessary.
All right. State? Okay, then I'm ready for the presentation of evidence. Mr. Taylor.
We would call Barbara Russell, Your Honor.
Oh, my word. You're calling Barbara Russell? The psychologist who went on podcasts? Okay. All right. Here we go. The one that Ashley moved in with.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Good morning, ma'am. As you've heard me say multiple times before, just get about 12 to 15 inches from the microphone. It does adjust up, down, left, right, but if you just speak in a loud, clear voice, we'll be able to hear everything.
Good morning. Would you tell us your full name?
Barbara J. Russell.
And tell us a little bit about your education.
I have a master's degree in clinical social work. I have a doctorate in clinical psychology.
And the current position that you hold employment-wise?
I am self-employed. I have a clinical and forensic mental health practice.
How long have you had such a practice?
For about 15 years.
Would it be correct in addressing you as Dr. Russell?
Yes, certainly.
All right. Dr. Russell, have you appeared before in the courts of the state of Florida and been recognized as an expert?
Yes.
Can you give us an idea of approximately how many occasions?
Typically, I testify in court as an expert in the state of Florida about 3 times a month for the last 8 or 9 years.
Have you, in that capacity, appeared in the courts of Manatee County on a regular basis?
Yes, sir.
Specifically, have you appeared before Judge White in previous proceedings as an expert on mental health?
Yes, sir.
I want to ask you, Dr. Russell, amongst your other specialties, are you qualified to diagnose and treat PTSD?
Yes, it's one of my specialties in both my clinical and forensic practice.
All right, would you tell us what PTSD stands for?
Post-traumatic stress disorder.
And are you also qualified, in addition to PTSD, Dr. Russell, to treat domestic violence and abuse?
Yes.
Can you give us an idea of your experience in the domestic violence area on behalf of both abusers and abused?
I'm a certified nationally certified domestic violence clinical specialist. I have treated victims since early 1990 in various outpatient services, providing support groups, individual counseling. I have, for Circuit 12, provided court-ordered domestic violence intervention classes for offenders for about 8 years.
Right, and among other instances, have you been involved with the Batters Intervention Program as well?
Yes.
I want to ask you a few questions about Douglas Benefield. Did you have an opportunity in your capacity as a psychologist to interview him?
Yes.
Do you recall approximately when that would have been?
That would have been in April of 2020.
And approximately how long did that interview last?
He spoke with me for about 90 minutes.
Were you satisfied during the course of that interview that you had sufficient time to render a diagnosis of Mr. Benefield's personality?
Between that interview and also the collateral data, the documentation that I viewed, yes, very much so.
Would you tell us what that diagnosis was and your basis for it?
Douglas Benefield exhibited criteria that met the diagnostic categories of narcissistic and antisocial personality disorder.
And how, if at all, would that fold itself into being a potential abuser?
Well, the antisocial components, as well as the narcissistic components, he had little to no empathy. He really lacked the capacity to take responsibility for his behavior. He had a desire to be admired, to have constant attention. He felt very entitled and demanding to the attention and admiration of other people, whether or not he did anything to deserve it. And he had little regard for the rights of other people.
Are you familiar, Dr. Russell, with Ashley Benefield?
Yes.
Do you have an opinion as to whether or not Ashley Benefield, as she sits here today before you, is currently suffering from any specific condition?
Yes.
Would you tell us what that is?
Ashley is suffering from post-traumatic stress.
And are you able to give us some insight into the basis that caused that syndrome that she suffers from?
It's really been caused by complex trauma. The root cause all comes down to the abusive relationship with Douglas Benefield. From the time the abuse began in their marriage up until the incident of the attack that led to the shooting on September 27th, there have been multiple situations that have severely distressed and traumatized her.
So I want to ask you a couple of questions about post-traumatic stress syndrome, and I'll use as an example the soldier that comes home from combat. Is there anything about this syndrome that requires or necessitates an instant response to stimuli immediately after the traumatic event, or is that liable to happen at any time over the spectrum of conditions and circumstances that that individual may experience?
Symptoms can be delayed onset. So somebody can experience a severe trauma in January and perhaps not exhibit any kind of reactivity to stimuli that reminds them of that, or any emotional distress for days, weeks, months, even years later. So it's not unusual to see in November somebody have a problem, or even, again, years later. Delayed onset's common.
So again, using this hypothetical soldier as an example, 3 months after they return home following combat duty, they may not respond to any stimuli, but you're telling us as long as 18 months, 2 years later, when a spoon happens to fall into the garbage disposal and makes a clattering noise and they dive onto the floor, that would not be unusual.
No, it would not be.
Are you familiar, Dr. Russell, with the facts of this case and the circumstances surrounding the shooting?
Yes.
Do you have an opinion as to whether or not Douglas Benefield's conduct contributed to his death?
Absolutely.
Objection and proper opinion.
Overruled.
Yes, absolutely.
And how so?
Douglas Benefield had a history of violent behavior. Douglas had been threatening Ashley, becoming increasingly aggressive in the weeks and days leading up to the shooting. He had been making verbal threats to her life. He was in her home. He was refusing to leave her home. He was acting in a manner very typical of Doug, only exacerbated at that time. He behaved in a manner that made her feel as though her life was in danger, that she was at serious risk of being killed or being seriously hurt.
Did there come a time, Dr. Russell, when you were approached by representatives of the Manatee County Sheriff's Office who asked that specific question?
Yes.
Did you respond to them with basically the information you've given us here today?
Yes.
tell us about whether or not you have formed an opinion as to Miss Benefield's psychological state at the time of this incident.
At the time of the incident, she was acting under extreme duress. She was in full survival mode, fully believing that her life was in danger. She was responding with an effort to stay alive. There's a process that happens in the human mind when we feel that our lives are in danger. We have to make survival decisions, and these decisions are made in fractions of seconds. Even outside our conscious awareness, we're assessing the situation, assessing our capacity to escape, assessing our capacity to fight back. And people make decisions based on what their survival brain, as I call it, tells them is going to keep them alive. She was doing what was biologically natural in a situation where somebody would feel that their life was in danger. And this was also compounded by the weeks, months, years of knowing Douglas Benefield to be violent and being afraid of him.
Did you, Dr. Russell, have any opportunities to actually observe Ashley Benefield's reaction around males and the manifestation of this post-traumatic stress syndrome and her comfort level?
Yes.
Tell us about it.
In the weeks, really the early months following the shooting, when Ashley was staying at my home, I would notice in particular, she would frequently apologize for things that didn't require an apology. She especially did that around my husband. If she was in the kitchen making a protein shake in the morning and he came in to make coffee, she always felt like she was in the way. She was always very quick to say she was sorry, to kind of flinch or pull back in a manner that was just completely, appeared to be unnecessary based on the situation. You know, there was never any indication from him that she was being bothersome in any way. But she had an expectation that she was going to get yelled at or that somebody was going to be mad at her. I had noticed another occasion, my son had stopped by our house in the evening. It was dark unexpectedly. She looked out the window and saw a male figure approaching, and she came screaming through the house saying, "Someone's here, someone's approaching the house." She was very hyper-aroused and reactive to situations, particularly with men.
Your Honor, I don't believe I have any further questions for Dr. Russell.
Cross?
Are you familiar with something called histrionic personality disorder?
Yes.
Can you explain about it?
Histrionic personality disorder is a pervasive pattern of a person being very melodramatic to gain attention.
And are you aware that the defendant in this case has been diagnosed with that?
I'm aware that that's a false diagnosis, but yes,
So in your opinion, it's a false diagnosis? But
absolutely. Women who've been victimized by domestic...
I didn't ask the question.
Excuse
In
me,
your-
excuse me. She's, Dr. Russell.
Let her finish. Go ahead, ma'am. You finish your answer.
Yes. Women who have experienced victimization of intimate partner violence are often mischaracterized as being histrionic when the individual assessing them does not have a proper understanding or a complete picture of what has been going on in their lives.
And according to your beliefs, you believe that you do have that background and you are able to diagnose it quickly.
Absolutely.
And would you consider yourself unbiased when it comes to Ashley Benefield and Doug Benefield?
Absolutely.
Okay. So after you had your initial evaluation with Ashley Benefield, that was in, I think, April of 2020,
Correct.
you continued contact with her,
Correct.
and she had your phone number,
Of course, all of my clients have my phone number.
and she would call you on a regular basis.
She would call me on a regular basis to update me on what was going on in her situation, per my instruction, as there was potentially an upcoming court hearing regarding her situation.
And she would copy you on emails to her attorney.
I don't know. I don't recall that.
There were several emails that were sent to her family law attorney that had you CC'd on them.
Okay.
Would you agree with that?
That's a real possibility.
So as a therapist, is it normal to have a client CC you on their correspondence with their attorneys?
Yes, if I'm involved in a capacity where I could be testifying at a family law hearing or at an injunction hearing. That's very typical.
Okay. So several months, well, several weeks, I suppose, after this homicide, she moved into your house.
Yes,
And your house, she lived with you, your husband, and your daughter.
correct.
And she lived there approximately a total of 8 months.
Approximately, yes.
And the night that this shooting occurred, you were called on the phone.
I was called by her attorney, yes.
Okay. And you showed up to the house where the murder happened.
Where the shooting happened, yes.
Okay. And that's a normal part of being a therapist? You show up at somebody's house when there's been a crime?
I have shown up at people's houses, at their place of employment, at a hospital emergency room. Crisis intervention is very much a part of being a mental health professional.
And you know about the demonstrators that were out in front of the courthouse on numerous occasions during this case, correct?
Yes.
Holding signs, Free Ashley.
Yes, that's the Community Defense Committee called We Stand with Ashley. I'm familiar with that.
On numerous occasions, you were also out there holding signs.
Yes,
And marching with this group.
yes,
And you still consider yourself unbiased?
absolutely. It's part of my ethical obligation as a licensed clinical social worker to be involved in situations that involve injustice.
Now, you said that you were able to diagnose Doug Benefield after a 90-minute phone conversation and I believe you said collateral documentation.
Yes,
And a lot of that collateral documentation a lot of it included the paperwork for these injunctions that Ashley Benefield was trying to get against Doug Benefield, correct?
what do you mean by the paperwork?
The recitation of what Ashley said Doug had done and the things that she was trying to tell the court that Doug had done, trying to get the injunction.
No, that had nothing to do with my forming my opinion. In fact, the documents that I looked at that formed my clinical opinion of Douglas Benefield were mostly things that he documented, that he wrote, that he did. It was based on his behavior, not what somebody else says about him.
But it did include what Ashley Benefield said about him.
Not the documentation that I formed my opinion about him. Absolutely not.
Are you saying that what Ashley Benefield told you had nothing to do with your opinion?
My opinion in what was going on with him clinically had to do with the words that came out of his mouth as he talked to me for 90 minutes and the various correspondence and documentation that came from him, his emails to other people, things that he had documented, things that he told me that he did.
Okay, so after this evaluation and right before the time of the shooting, you said, I believe, that Doug was increasingly violent and it was becoming more dire, right?
Yes,
And you knew this because Ashley told you.
yes.
You didn't witness this for yourself.
No, I did. The only thing I witnessed were some of the text messages that he was sending her.
Okay, but you never saw any of the other evidence that he was becoming increasingly violent.
No, it was what she was reporting to me that he was saying and the messages that she was forwarding, some of which were quite threatening in nature.
I have no further questions, thank you.
Redirect?
No, sir.
All right, thank you very much, ma'am.
Thank you, Judge White.
All right, did you have anybody else that either had testimony or wanted to make statements?
Statement by me or further testimony?
Oh, just closing?
Thank you, Dr. Russell.
Just closing?
As to the departure issue,
Yes, sir. All right. State, did you have any victim impact statements, any letters, anything that you wanted me to consider?
Yes, I have several people here that would like to speak, if now is the time.
Yes.
Your
I would
Honor, I'm
like-
sorry.
Yeah.
I want to just make sure the court didn't misunderstand. I did want to make a statement about the departure issue consistent with the testimony that the court just heard from.
Okay. Yeah, what I meant is I normally let the defense go first. So if there's any witnesses you want to put on in support of downward departures, any evidence you want to introduce in support of downward departures, anything you want to have me hear about sentencing, I want to hear all of that. And then I'm going to go to the state and I'm going to hear any evidence they want to present, testimony they want to present, victim impact statements they want to present. I do it globally.
Okay, so you want the whole shebang now?
Yes, exactly.
All right, fine. I'm ready.
Oh, okay. All right.
So let me.
Well, hold on. Let me make sure we need to be on the same page.
Yeah.
At this point, I'm still in the evidentiary portion. So if there's anybody else, if there's any other letters, cards, statements, other information you want me to consider, if there's any statements that any witnesses want to make here in open court in support of Ms. Benefield, I'll be happy to hear all of that. If it's argument in favor of the downward departure, I will hear that after I hear from the state and their witnesses.
Okay, and that was my initial understanding. Then once I give that, I will then complete my remarks as to sentencing.
Absolutely.
Okay.
Once we finish with the evidentiary portion, then I'm going to go closing, closing, closing.
Understood. Thank you, Judge.
Yes, sir, absolutely. All right, state.
So the first person, Judge, is Dave Benefield, who is Doug Benefield's brother. State.
And I'm going to have them sworn in.
I'm sorry.
Even if it's a statement, they'll be sworn in.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
All right, sir, if you could please.
Everyone, it's time for victim impact statements. So, okay, first up will be Dave Benefield. I'm sure that Doug's daughter will also speak. If you already know, please don't give us spoilers. We're watching it live together now for the first time, even though we're a little bit behind the live court feed. We did that intentionally, right? So, victim impact statements. And then let's see, the defense, was that the only witness for that? For the what did they call that? The downward what? Departure. Okay, let's hear what Doug's brother's got to say.
Please state your full name for the record and then tell me what you want the court to know.
I'm David King Benefield, and I'm just wanting to provide a victim impact statement.
Yes, sir.
Thank you. I want to thank you for your excellent and just governance as you presided over this trial. Throughout this entire tragedy, I witnessed the steady progress of the due process of law that is meant to be at the heart of our country's justice system. To you, to Manatee County, to the entire Sheriff's Department, and to the state's prosecution team, I offer my deepest and most heartfelt appreciation. It is impossible to convey the depth of loss and grief that I feel daily at the death of my brother, Doug Benefield. On Monday morning, September 28th, 2020, Eva Benefield, my 19-year-old niece, called. She worried that she had not heard from her dad. He was not answering calls, which was very out of character for him. And soon after, I received a phone call that my brother was dead. On a call that included my cousin, Tommy Benefield, and Doug's family law attorney, Stephanie Murphy, we added Eva to the call. Eva immediately asked what was up with her dad. I was in a state of disbelief and shock. I couldn't get the words out of my mouth. Before I could muster up the words to answer her, Eva exclaimed, "She killed him, didn't she?" The next couple of days are a blur as we spent time processing Doug's life, his death, and how to respond. Tommy and I picked up the U-Haul with Doug's belongings from Alicia's house, consolidated his few remaining belongings at his apartment in Bradenton, found where Sully had been boarded up for their planned move, then headed to South Carolina to meet up with Eva and to meet her needs. There were decisions to be made, belongings to consolidate, bills to be paid, and now the unthinkable decisions about investigations, communication with family and friends, autopsies, and the unfathomable what to do with Doug's body. Doug's body was still in Florida following an expedient autopsy. I just had to see him before he was cremated. I struggled to believe it, and I needed to see him. Up until that point, I had not cried. I was numb. Tommy and I went into the office of the crematorium while they brought Doug's body out. As I looked at him through a stained a glass window, I began to weep, and I could not stop. As we got into the car, my weeping turned into loud wails. Tommy sat with me in the car while I wept and wailed uncontrollably. I have never experienced anything like that kind of grief and emotional pain. As I sat there, I had one of the most profound moments of my life. I trusted Jesus Christ as my Savior in 1985. I was living with my brother, Doug, while we both attended Texas A&M University. We had heard that our Uncle Doug, a test pilot and a hero to all of us, had been killed in a B-1 bomber crash. My brother Doug was named after him. Following Uncle Doug's death, my brother played an instrumental role in leading me to Christ. He witnessed the immediate change in my life. I dropped out of my fraternity. I spent hours reading the Bible and learning to pray. Jesus captivated my heart, and the old destructive habits just fell away. Depression left and joy came in. Where I had felt so lost, I finally had a direction for my life. Doug and I shared our faith journeys from that time in college until his death. As I sat in the car at the crematorium, wailing and gasping for air, I did what I had learned to do all those years ago with Doug. I prayed. My prayers were my thoughts screamed to God as loud as I could think in the midst of my uncontrollable crying. I felt the strong and clear answers of the Lord with each prayer I prayed. I asked God, why do I hurt so bad? God responded, because you loved him so much. Why did I love him so much? God's response was a series of images and memories that came flooding back in rapid succession. I remembered him letting go of the sissy bar on my first bike ride without training wheels and laughing as he shouted, "You can do it, just keep pedaling." I remembered his encouragement at my first high school wrestling match. He was a very successful athlete and was always a state contender in wrestling. I was hyperventilating at my first match, and he was there to encourage me and help me overcome my fears. I remembered him taking me to a New Year's Eve jazz concert in Austin, Texas, during my first year in college. He knew I didn't have the money, and he paid for everything. I remembered even the little things that he made so special on that trip, like my first bagel covered with cream cheese and jelly when I didn't even know what a bagel was. To this day, every time I eat a bagel and cover it with cream cheese and jelly, I think of him. I remember his designer shirts that he let me wear, his coaching comments after my first fraternity meeting as president, the bedroom he built for me in a closet in our condo at Texas A&M, him gently but firmly correcting me after breaking his prized car when I took it out for a midnight joyride. And I remember my first cup of coffee in college that he made for me, and on and on. While these images were flashing through my mind, I heard the Lord impress me with this thought: you shared so many of your firsts with him. And the conversations with the Lord went on for quite some time. Why do we grieve with such pain? It is because of the glorious privilege God gives us to love deeply. I lost my dad to cancer at 12 years old, and my mom several years prior to Doug's death. But nothing hit me like this. God blessed me with two great brothers, and Doug, 2 years older than me, was such a gift to me. He was truly a hero in my life. Every day, I feel a kick in the gut from the loss of my brother Doug. I have spent hundreds of hours going through his well-kept records, literally tens of thousands of pictures of Ashley and Emerson, emails, and texts, as I have ordered his affairs and tried to find anything that would explain what happened or that corroborated Ashley's version of the events. Rather, what I have found in his journals, his extensive emails, and meticulous records was a man with his heart set on loving his family well at all costs. I grieved Doug's loss so much because I loved him so much. He was strong, but he never used his strength to hurt people. He used it to serve and to love and help people. Doug made life so much richer. He had so many unique facets. He was an amazing artist. He was a defender of the weak, a visionary, a strength that would comfort you, not concern you, a laugh that made everything seem okay, and a way of including you that made you feel deeply loved and appreciated. He generously shared his discoveries of the beauty of life. When I was with him, everything seemed so much more exciting and hopeful. His friendship humbled me. His giftedness amazed me. His kindness comforted me. His strength strengthened me. And his passion for life inspired me. Doug was patient, almost to a fault. He hoped and he trusted deeply in the Lord with an unshakable optimism. He graciously endured so much suffering on behalf of the others, as was witnessed in his astounding patience with Ashley. He genuinely believed the best about others. This can come across as being naive or gullible, and in our weakness, that is certainly a danger. This can also make you an easy target for people, but it is truly a great way to live. I will never forget talking to Doug on the phone the first time I heard about his relationship with Ashley and the hope he had for their future. He eventually told me of his hopes for their marriage, their daughter, and all the endeavors they dreamed of in the future. I could not have imagined a more horrific ending to their story. I knew my brother intimately. Doug was absolutely not the monster Ashley alleged him to be. He was the complete opposite of what the defense was presented. The primary evidence against Doug was his sworn testimony in family court, where he admitted to actions he deeply regretted that occurred on a single day 3.5 years before Ashley killed him. The defense presented a slander campaign based upon gross exaggerations of Doug's own testimony and unverified allegations from Ashley. Doug patiently endured Ashley's verbal, emotional, and legal abuse for over 3 years and was still willing to reconcile with her, even serving her up until the time of his death. The month before Doug was killed, I spent 4 days with him in Mount Pleasant, South Carolina. He expressed to me his desire to help bring healing to Ashley and her mother from the trauma that they had experienced in the past. Doug realized he might not be able to salvage the marriage. He was resigned to being a single father and working with Ashley to care for Emerson. He was not angry or bitter, but filled with mercy and resolve to make the best of the situation. That was the brother I knew. His lover and his love and compassion for his family was unshakable. Ashley, I want you to know that I forgive you. You have caused me the greatest loss that I have ever experienced, one that almost daily causes me to completely stop what I am doing and weep from the overwhelming loss I feel. Doug touched every part of my life, and I can't process this senseless tragedy. But as Christ has forgiven me for my wrongs, I also forgive you. I do not hate you. I grieve for what your actions have and will cost you. It is again the exact opposite of what Doug sought for you and for Emerson when I think of you. I pray for your healing, the healing of your family, and for God's grace over Emerson as she grows. This is the very same thing that Doug told me was his desire for you 7 weeks before his death. Little did you know that the man that you sought so aggressively to get out of your life was a gift to you who had counted the cost to love you no matter what the cost, even his life. I found out after his death that there were many people who strongly encouraged him to leave you, even some who expressed concern for his life. But he would not give up on you. Ashley, Doug's love was but a fraction of the love that God has for you. And I pray that you will experience God's forgiveness and mercy that only comes by knowing Jesus Christ and his cross and truly believing in him.
All right, thank you. State.
Next, we have Wes Benefield.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, sir, if you could please give me your name and then tell me what you want the court to know.
Yes, sir. My name is John Wesley Benefield Jr., Doug Benefield's older brother.
Yes, sir.
Thank you, Your Honor, for allowing the Benefield family to be heard. I ask the court to give Ashley Benefield the longest possible sentence for the egregious cold-blooded murder of her brother Douglas Glass Benefield. Doug has always been a man of faith, loved his family, loved this country, and his friends. The Benefield family has had a very long history for many generations of protecting this country, protecting others, helping others. Doug was a naval aviator after graduating from Texas A&M. Went on to do great things in life. Doug has a beautiful, smart daughter, Eva Benefield, who does not have a father anymore. Unfortunately, Eva's mom, Renee, passed away a number of years ago due to health issues. We all miss Renee, a wonderful wife, mother, and person. Ashley Benefield had an opportunity to make a great marriage, a partnership with Doug, be a great stepmom to Eva. We all know now what Ashley has done by murdering Doug in cold blood. Ashley doesn't care. She didn't care about Doug. She did not care about Eva. Ashley treated Eva horribly, while Doug and Ashley were under the same roof in the beginning of their marriage. When Ashley had Emerson, their daughter, Ashley did not even tell Doug that she was born. As we found out in the jury trial, Ashley did not even recognize Doug as the father on the birth certificate. That's my understanding.
Judge, excuse me, I apologize for interrupting. I don't think tagging the defendant is part of a victim impact statement, so I can probably just ask the witness to move on to a different part of the statement.
I'll sustain.
Oh, so the defense can attack the victim who's deceased, who can't speak for himself. Victim blaming is okay, according to the defense, right? But not the defendant. Well, the convicted, because she was found guilty. Okay.
Ashley treated Eva horribly while Doug and Ashley were under the same roof in the beginning of their marriage. Here?
Yeah.
The Benefield family has always been a very close family. We always had a great time together when we were all able to get together. We would catch up, have great meals together. We have a great God-loving family. Now we do not have Doug anymore. Eva does not have a dad anymore, or a loving mother, Renee. I'm retired law enforcement, retired deputy, Brazoria County Consul's Office, Texas, the south side of Houston. As the court, the sheriff's office, and the state attorney's office have seen and dealt with animals that murder, steal, rape, home invasions, pedophiles, so have I. When you look at these egregious offenders, once they get out of incarceration, many of them go back to the streets and continue to commit the same type of aggravated offenses until they're caught again. During the jury trial, Ashley would occasionally look at me and my family with this arrogant smirk, showing that she...
Same objection. I apologize for the interruption.
Sustained.
In conclusion, I respectfully ask for the full sentence of incarceration due to the cold-blooded murder of Doug Benefield. I'll give you one last example of how we know Ashley doesn't care about Doug and the Benefield family.
Again, objection. Same
Sustained.
basis.
Oh, shame. They can't say what they want to say. That's always sad, right? So I'm asking you on a poll during the live stream, did you watch the trial? 23% say no, 30% yes, but only some of it, and 47% said that yes, the whole trial. And I see some people asking, did I cover the trial? Yes, there's a whole playlist for this case. I'm going to change the name to the Ashley Benefield trial. It'll be easier to find. It was called the Black Swan trial in the media, so that's what the playlist is called. But I'll make it very easy to find. It's also in the description box of every single day, okay? This one as well. So let's keep going.
Okay. Your Honor, thank you again for allowing us to be heard.
Thank you, sir. State.
Tommy Benefield?
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, sir, if you could give me your full name and then tell me what you want the court to know.
Yes, sir. Tommy Douglas Benefield, Jr. I had one younger brother, but my relationship with Douglas Benefield was even closer than that. Douglas was named after my father, a very famous Naval Air Force aviator, test pilot, combat veteran. And Doug followed in the footsteps of my father, much the way many of our Benefield family did. We heard from the expert who spent 90 minutes with Doug, but I spent 59 years with Doug. We knew him much better than any 90-minute expert. Before Ashley was born, Doug was a graduate of Texas A&M in biology with scores high enough to get into medical school. Because Doug was raised in a very middle-class family, did not have the money or scholarships like today to go to medical school, he chose to go into the Navy program that I helped sponsor him into, which led to him spending 3 combat tours off of aircraft carriers in the Western Pacific and in the Middle East. Doug was both a naval flight officer, meaning that he was a warfare officer, aviation warfare officer, and he also flew the airplane, which was unusual at that time, but something that he could do like many other things. In 1992, he went through 1-year training as an intelligence officer for the U.S. Navy and eventually for the Defense Intelligence Agency. During all those trials and tests in the Navy and in the intelligence plans and purposes, Doug was always tested to the highest levels to make sure that he could withstand the stress of combat, the stress of life, and separate those two things well. After becoming an intelligence officer, his other job, his public job, was as a mine warfare officer and instructor at the Navy's Mine Warfare School in Charleston, South Carolina. He did that for 3 years. After that, he went 3 years for the Defense Intelligence Agency as an analyst and a technical operations expert. In 1999, he left active service but stayed in the reserves and continued his service to this country for almost 20 years. In 2000, he married Renee, his longtime amazing wife. In 2001, their daughter Eva was born, who's here today, and you'll hear from after me. 2015, after a long run, Renee passed away, despite what the defense has alleged, of a heart attack under natural conditions. Doug became a single parent, like I was many times in my life, unfortunately, and in 2016, he met Ashley. I met Ashley April of 2017. I remember the first encounter. I remember being at the home at 701 Preservation Place. I remember the calm and comfort, the love between them at the time. But a few months later, Ashley separated from Doug under one purpose, saying that she was having trouble with her pregnancy, but with ulterior means. And that is the history that we know through this process. What most people know about Doug Benefield is when he was 12 years old in 1971. Like Doug, who could figure out things that no one else could for this country, for the special operations warfare operators, for the emergency responders, Doug, Wes, and David's father figured out how to use microwave and laser systems to communicate and track space objects before anyone understood what that was capable of. That was 1971. Like Doug, was passed on to him one of Doug's current technologies that no one in the world could figure out but Doug. It's called transpositional modulation. It's a radio frequency waveform technology that offers dramatic bandwidth increases and novel security functions for existing wired and wireless networks. There's a multi-billion-dollar corporation founded on the fact that Doug Benefield could figure out how to make two signals go on the same frequencies at the same time. That accomplishes what no one thought possible, the simultaneous transmission of two or more distinct data paths on a single carrier signal. Quantum physics in use on 5G networks all around this country today. He also founded the patents that would lead to secure data via quantum physics that encrypts swiftly and securely all data that's unhackable even in today's world. Right now, here's just some of the patents that are in use under Doug's name. Lighting control devices and methods. Task ambient heating and air conditioning systems for distributed space conditioning. Methods and systems for air quality analysis, diagnostics, and environmental controls. Heating and air conditioning fire suppression systems. And even the most craziest one of all is called free space optical transmission system for vehicle networking. The reason that our cars, more importantly our special operators all around the world in the Western world, can data transfer from sole operators behind enemy lines to their command and control is because Doug Benefield figured it out. John 10:10 says to us, the thief comes only to steal and destroy, as opposed to Christ, who's come that they may have life and live it to the full. I believe that the people who have supported Ashley have been deceived. They've had stolen from them their time and their effort. That
Judge, I'm going to object on the same basis. It's not a proper victim.
Sustained.
No worries. There's been no question in my mind or in this court under the Stand Your Ground hearing, which was found that Ashley did not have a self-defense enough to reach that threshold, that she stole from Doug. There's no question that she killed Doug.
Judge, same objection. I'd ask the state to direct the witness to give appropriate victim impact.
Judge, I would disagree. It is allowed that the victim's family can make statements about the defendant. I understand if the defense is asking that they not, make broad
Characterizations and opinions about the crime, the defendant, and the appropriate sentence shall not be permitted as part of the victim impact evidence.
I'll take care of that, Your Honor. I'll
Yes,
make sure.
Thank you.
And you're reading that from?
921.141 sub 8, how I started this sentencing hearing was, this is not a capital sentencing. However, when I do sentencings, I think those are good guidelines to use in formulating the nature and extent of a victim impact statement.
No problem,
Sir.
sir. I'll wrap it up, and I'll be careful.
Sir, tell me everything you want to know. The victim impact evidence is designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death.
Yes, sir. I believe I've done that so far, and I'll finish it with that, sir. What saddens me personally is the loss of Doug to our family, to Eva in particular, who has no parents, as she said and demonstrated. The worst part of it is that there's a 6-year-old that will grow up not knowing the man that we've known all of our lives. The loss to this country and to the Western world of the brain, the smarts, the ability to problem solve in a way no one thought possible, that all the engineers said couldn't happen, was something unique to Doug Benefield that was stolen from us, our family, his daughters, and the world. And I'm sorry that we're here, but that's the theft that's happened. That's the loss to this country that's so much greater than anything could possibly be replaced. I personally, our family asks for a minimum of 25 years and the maximum of possible of 30 years, Your Honor, due to the grievous loss of killing Doug Benefield by Ashley Benefield. Thank you,
sir.
Your Honor.
And I
All right,
believe
State?
lastly, we have Eva Benefield.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, yes, ma'am, if you'd please introduce yourself to the court and tell me what you want me to know.
I'm Eva Benefield, Doug's daughter. When my dad moved from Charleston to Florida, I was a little over 18 years old and preparing to go to college. He was on the road a lot, and I would occasionally see him when he passed through South Carolina on his way up north. Although I did not get to see him as much as I liked, he was always a text or a phone call away. After my mom died, my dad knew it was important for him to answer the phone as soon as he could. He was out of town when she passed, and I had been trying to call and text her after school for what felt like hours of waiting in the carpool pickup line. After finding her later that evening, any time my dad didn't answer, it sent me into a spiral. My brain automatically went to the worst possible outcome, thinking something terrible happened. My dad's colleagues can attest to the fact that even if he was in the most important meeting of his life, when I called, he would step out immediately and let me know that he was in a meeting and he would call me back as soon as possible. My dad usually woke up in the very early hours of the day. The first thing he sent me was always a Bible verse followed by, "Good morning, pumpkin." This was his way of letting me know that when he was awake and he was available for me to call him when I woke up and tell him about the day I had ahead of me. The morning of September 28th, I woke up to no messages from my dad. I wasn't alarmed quite yet. Sometimes he rushed to the gym or had to immediately get to his computer for work. As the morning droned on, I anxiously awaited a phone call or a text message from him. Around lunchtime, I began Googling about traffic accidents in Sarasota, Florida. My friends told me, I told my friends I was worried, and they let me know I had nothing to worry about, that my anxiety-ridden brain was just flocking to the worst possible outcome. 9:24 a.m. Good morning. 10:42. Hello. 10:43. You're kind of scaring me. 11:20. You should definitely text me so I know you're okay. 11:48. I'm about to text Ashley. 11:49. Just kidding, I don't have her number. 12:03. This is freaking me out. 12:55, please, please, please answer. 12:56, great, now my texts aren't going through. 12:57, I hate this so much. It was about an hour later that I received a phone call from my uncles that my dad had been shot the night before. Is he okay? I asked. My uncle responded with a hesitant no. My next question before hanging up the phone was, she did it, didn't she? Ashley, since the day you shot my father, I have only had one question to ask you. Why? Why did you end my dad's life knowing he was my only living parent and the only person I could confide in and count on for everything I needed as I turned into a young adult? Why did you willingly take away your daughter's father, knowing the consequences of your actions would leave her without either parent to help her navigate through her own life? You somehow managed to orphan not one, but 2 young girls. Unlike Emerson, I am fortunate enough to have known my dad for a full 19 years before you ended his life. He taught me how to paint. He attended every extracurricular activity I had. He took me to dinner on Valentine's Day. He drove almost an hour out of his way every day to drop coffee off in the school office for me and my friends. When he was in too much pain to surf with me, he would sit under an umbrella on the beach all day during the hottest months of the year. He would cut fresh flowers from the garden every morning before my mom woke up and left them on her bedside table. While I ran in the mornings before school, he cooked breakfast so it would be ready on the table when I got home. Every Saturday, we made oatmeal cookies together. Every Sunday, we would go to church and get a coffee after. When you moved into my childhood home, I watched my dad fix the door frame with a crack in it from where the neighbor had to knock the door down to get into the house after my mom died. I watched my dad paint over every memory in every corner of that house, change the furniture, rid the house of every bit of my mom that was left so you could enjoy life without remnants of my dad's late wife and soulmate. I had to come home from school to see you barely clothed, sitting on the countertops my mom used to cook our family dinner on. I had to live in a house stripped of memories I still cling to so I can remember the happy childhood my parents gave me. Not only did you make my home nothing more than a house with 4 empty walls and a roof while I was grieving the loss of my mother, you tried to bring my mother's sweet spirit into your soulless world by spreading lies that she was killed by my own dad. You got medical records pulled, and you were moments away from getting her removed from her own grave.
Apologize for interrupting with the same objection. I don't think attacking the defendant is appropriate dictum in that statement.
Sustained.
When you left my dad the first time, I watched his face as he read the letter you left on the bed for him. The house was quiet that day, and while I felt sorry for my dad because I saw the pain in his eyes, I was secretly excited to have my dad back. Those few months that he received nothing but radio silence from you, I was able to finally regain the relationship we once had. Things finally felt normal again. Easter weekend of 2018, my dad insisted that I drove to Florida with him so I could enjoy Easter Sunday with my half-sister. The night before Easter, you and Alicia pulled me aside before dinner to try and convince me that my dad was a monster, that he killed my mother, that he was evil and I was unsafe. The next morning before you brought Emerson over to open Easter baskets, my dad could tell something was off.
Shut, same objection.
I can see 2 ways this could go. It could come back around. I don't know where it's going, though. I don't know what the next statements are. If the next statements contrast that with with evidence designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death, then I'll overrule the objection. If not, I'll sustain.
While I feel deeply sorry for everyone who was affected by these last few hurricanes this year, they couldn't help but remind me of the time my dad drove 8 hours through a hurricane to come help you board the house you lived in at the time. My dad was the opposite of what you have attempted to portray him as. Doug Benefield was kind to a fault, he was smart, he was strong, and most importantly, he was generous. His generosity is what got him killed. December 2nd, 2014, 10 years ago yesterday, my dad was out of town when I found my mother dead on the floor at 14 years old. Her funeral was the first and only time I saw my dad cry. Not even a year later, he met you during what I imagined to be a very lonely part of his life. You decided to put on your biggest act of your career and pretend to be everything he needed to fill a void. I watched
Judge,
him.
same objection. Again, apologize for interrupting.
And Judge, I think she can talk about her dad and how he took this in and was kind. Even,
If that's where it's going, but as I've said multiple times, and as I'm pretty sure I confirmed before we started, that the state had gone over with its witnesses,
Yes.
the nature and extent of an
I
appropriate
just have
victim
a
impact.
difference of opinion as to what they're allowed to say, Judge, so it's
I'm
difficult
going
for
by the
me
Florida
to-
law,
For death penalty cases.
and I said that it's appropriate. I think they're good guidelines.
I watched him bend over backwards for your every need. For years, he gave you everything he had, time and time again, trying to show you, Emerson and Alicia, nothing but love. He wanted nothing more to show you what true acts of love are. You took advantage of his willingness to give, and he gave you his life. After my dad passed, there were a lot of sleepless nights contemplating if my life was even worth living. I had no financial help, no parental guidance, and no will to live. The idea of ending my own life was oddly gave me some sort of satisfaction knowing you would have to live the rest of yours with blood of two Benefields on your hands. Shortly after those dark days, I realized I would selfishly be doing my parents a disgrace to not live every day to its fullest as they had taught me before they passed. I also realized that not only would you not care if I was dead, it would probably be beneficial to you. I'm the only one who can speak truthfully on behalf of my father and fight for his justice. While the grief of my parents will always live within me, what hurts me the most is not the thought of not having my dad anymore, because I will always have him around in spirit as I continue to implement the lessons he taught me during my adult years. What breaks my heart the most is thinking about how he found you at such a vulnerable part of his life, gave you everything you asked for. After you shot him while he was unarmed, he laid there bleeding out, unable to speak or to breathe, completely helpless and dying alone.
All right, thank you, ma'am.
Thank you.
State, did you have any other victim impact statements?
No, Judge, that's it. Thank
All right. Any other evidence that you were going to submit? Any letters, documents, anything?
you. No.
Okay. Rebuttal evidence or statements? Or just argument?
I have some argument to the board.
Okay, so I'm going to consider the evidentiary portion closed. We're going to begin the closing arguments. And so we're going to go defense first, then I'll go to the state, then I'll come back to the defense for rebuttal.
I wonder why the judge has set the bar so high for victim impact statements here, you know? They couldn't say much. Shame for Eva, but I think she did really well, right? Mooney says 13 months. Judge, give me the max to celebrate. Thank you, Mooney.
Before addressing my closing remarks, I want to address the downward departure specifically.
Now, I'm sure you guys are in favor of this, okay? I'm going to speed Mr. Taylor up a little bit, okay? Because he speaks a little bit slowly for us. We found that in the trial. It helps a little bit, right? Okay, I'm just going to speed it up a little bit. So here we go.
Make two comments. One is to the victim's status. I want the court to recall the independent evidence that was adduced at trial, for the moment excluding Ms. Benefield's testimony. Specifically, Doug Benefield's admissions establishing a prior history of domestic violence. There's obviously a dispute, and it depends to a great extent through whose lens Doug Benefield is viewed. Perhaps the truth is best found in the testimony of independent witnesses, because family who loved Doug Benefield sees him in one light, and the independent witnesses see him in a different light. So we not only have the admissions that did not come into evidence at trial, but I know that the court is aware of, and of course, this being a sentencing hearing, the formal rules of evidence are not applicable. And in those admissions, Doug Benefield not only admitted to various acts of domestic violence. I don't think an act such as firing a firearm in the kitchen of a home into the ceiling, specifically acknowledging that you did it to intimidate your wife into stopping to speak, is the kind of act that one is able to say, gee, you know, in hindsight, I've thought about it and I was wrong. Forgive me. there are certain acts that manifest a much deeper problem. And those of us that are members of society who have never so much as contemplated such an act realize that it speaks to a much deeper problem. So, we not only have Doug Benefield's admissions under oath of these various domestic violence incidents, but we have him violating the South Carolina court's domestic violence injunction, his efforts to purchase the house behind Ashley Benefield's while the domestic violence injunction was in full force and effect, placing a tracker on Miss Benefield's car, being caught by a neighbor at night lurking in the backyard, and the independent expert testimony from not only Dr. Jason Quintal, describing Doug Benefield as super controlling, a real alpha male, and intimidating, quote unquote, as well as Bruce Ferris, who said that Doug Benefield was a classic abuser, who showed all the textbook characteristics. And then, of course, the text message from his deceased wife, Renee, clearly explaining about being physically abused on their honeymoon. I think that the facts establish, for purposes of a downward departure, Douglas Benefield's contribution to this incident and the threat that he posed to Ashley Benefield. And because of that, I believe that the defense has clearly met their burden by a preponderance of establishing that Doug Benefield was a willing participant in the conduct that led to this shooting. The second basis, Judge White, with respect to departure, would be the extreme duress that Ashley Benefield was under at the time of the shooting. The expert testimony the court heard from today from Dr. Barbara Russell speaks to that. And the only testimony that is in the record that actually was put forth to recount the events of that date was by Ashley Benefield. There is no other testimony. And in that testimony, she clearly recounted not only the body checks that Doug Benefield delivered to her that day, the cardboard box assault, the false imprisonment when she tried to leave the house, the slap. It was very clear from the letter that Ms. Benefield left for Doug Benefield that she feared for not only her own safety, but the safety of her unborn child. She articulated that quite clearly in a letter written 3 years before this incident. That's either an incredibly prescient false flag that was planted or the truth. The truth of a woman who was scared. The truth of a woman who, despite what the court has heard about Doug Benefield from the family who loved him, obviously had a much deeper problem. I believe that together with those incidents, Doug Benefield's admission and the confrontation on that day, Ashley Benefield was clearly, as Dr. Barbara Russell explained, acting under extreme duress. And I believe that the burden as to that basis for departure was carried as well. With respect to closing remarks on behalf of Ms. Benefield, Your Honor.
That was quite dramatic. I was like, what is he going to do? Like, is he going to hug her? Is she going to stand up? Oh, he was getting a cup of water. Could he also, remember Mr. Healy in Leilani Simon's trial? Oh my word, with all the pen clicking. Well, Mr. Taylor is going, Taylor is going like that the whole time. Stop that, sir. Stop. Stop doing that in the mic. Oh my word, look at the judge's face. He's definitely got his snarky pants on.
I want to make it very, very clear that despite the exposure that Ms. Benefield faces to the court's potential sanction, she adamantly maintains her innocence, that she acted out of fear for her personal safety and shot Douglas Benefield in self-defense. The sound discretion of the trial court in ruling upon the admissibility of various evidence, that's the phrase that the appellate courts use to describe the authority of the trial judge, is the object of that discretion to ensure that evidence which comes before the jury is reliable and trustworthy? Or is that discretion designed to allow the trial court to manipulate the outcome of a trial to achieve a particular result? Jurors are told in every trial that there are two judges, the court, who is the judge of the facts of the law, and the jurors, who are the judges of the facts. But what if facts, essential facts, are kept from the jury? What if the court, rather than using its discretion to ensure the evidence is reliable and trustworthy, instead uses its discretion to undermine the effectiveness of the defense, to retard their efforts, to water down the impact of their position? Respectfully, that is precisely what we believe occurred here. Ms. Benefield was deprived of a fair trial, Judge White. Despite that, she was still acquitted of murder. Further, we believe that had the facts been put before the jury, Ms. Benefield would have been found not guilty. What then is our basis for that proposition? Let's start, if we can, with the court's order denying our stand your ground motion.
Judge, I'm going to object to going over the court's rulings being wrong. I don't really understand the significance of this in a sentencing. These are past orders, and we don't need to rehash them, but you disagree that they're correct.
All right, what's your objection? What, improper argument?
Improper argument.
Sir?
I believe, Your Honor, this is a sentencing under the rules of criminal procedure. We have an absolute right to address the court. I deliver my remarks not out of disrespect, but of counsel for a woman who faces 30 years in prison for a crime that she adamantly maintained she did not commit.
Overruled.
Thank you. In the court's order, the court stated that this was instead the culmination of a lengthy, concerted effort by the defendant to eliminate the victim from her life and the life of their child. When the defendant's efforts to enlist the assistance of law enforcement, Child Protective Services, and the judicial system failed, she took matters into her own hands, as she told Dr. Broder she would. So what happens with that statement is that we take the deposition of Dr. Broder, and I asked Dr. Broder in that deposition, now that would make your statement incorrect, would it not? And I'm specifically referring to Dr. Broder's statement that Ashley told him she was going to have to take matters into her own hands, thereby insinuating she shot Doug. And Dr. Broder's response was, in terms of that quote from the report, yes. I then asked, so based on that, those would be your words, not Ms. Benefield's, correct? And Dr. Broder answered, in the testimony, yes. Question, all right, and your comment referred to Ms. Benefield's decision to seek help from the Maryland authorities, did it not? Answer, that was her plan, yes. What's troubling is that Dr. Broder's testimony at the Stand Your Ground hearing then was at best mistaken and at worst a false implication to mislead this court. And the court bought it because it said, just as she told Dr. Broder she would. So we felt that the Stand Your Ground decision was based upon a mistaken statement by Dr. Broder under the best of circumstances. Now, what are the other issues that we feel deprive Ms. Benefield of a fair trial and precluded her from putting her best case, her best defense before the jury. There were a number of evidentiary rulings that Your Honor made. Specifically, Detective Warren's conclusion that he reached less than 45 minutes after the dispatch call came to him about the shooting, that the matter was a murder as opposed to a homicide. The court may recall that the lieutenant in that department testified that you can't make a decision about a homicide immediately. It takes time. You must investigate it. They could have applied for the warrant, Detective Warren could have applied for the warrant and secured it just as well by submitting that the potential crime that occurred was a homicide. Instead, within 45 minutes, he described it as a murder. The significance of that is that it shows his state of mind and whether or not this was always an incident and a bias towards Doug Benefield that they embraced. Doug was a man's man from everything that the court has heard from his family who loved him. He was very skilled at manipulation and was easily able to cuddle up with the detectives, and they liked him. And because they liked him, it influenced the objectivity of their approach to the case. We were never given the opportunity to establish that. Secondly, the email exchange between Detective Warren and Miss O'Donnell, where they discussed and participated in representing different facts for the purpose of securing an arrest warrant. Again, it went to their credibility. We were not entitled to get that in front of the jurors. The lead detective's perception, in addition to calling this a murder within 45 minutes, that, quote, all killings are murders and all who kill are murderers. This is the mentality of the lead homicide detective in the accusation against Ms. Benefield. We were precluded from demonstrating that before this jury to be able to argue with credibility that Ashley Benefield never had a chance. They decided, Detective Warren decided, within 45 minutes this was a murder, and then he did everything from that point on to support his position.
Are we reviewing the judge's performance and going over, the last 4 years? What is happening? Anyway, let's keep going. It's at 1.2 speed.
It went to the heart of this detective's credibility. The admissions by Douglas Benefield in his deposition of July 17, 2018, somehow the court concluded that that was not a statement against interest, which we bitterly disagreed with and still do, but more importantly, it was the integrity of the statement of the victim under oath that we were never able to put before this panel for them to make their own independent judgment. It's one thing for me, on behalf of Ms. Benefield, to be able to argue to the jurors that he made this statement. It's quite another thing for them to hear it out of his own mouth, and in particular, for them to hear that his explanation for it was that he blamed it on Ashley. This is classic abuser perception, that it was Ashley's fault because she would not stop speaking, and it was her fault that made him fire this gun into the ceiling of their home. It deprived the jury of clearly the most persuasive and compelling evidence that the defense could have put before them. That same strategy was employed by the court in keeping out the letter that Ashley Benefield wrote and left for Doug Benefield on September 17, 2018. I don't know that I've ever had an instance of a more specific state of mind exception to the hearsay rule than that letter. There is no way that anyone, I would submit, could articulate with the same decisive and persuasive influence on the jurors that that letter, seeing it, feeling it, reading it, would have accomplished had it gone to the jurors. In that letter, Miss Benefield not only stated how deathly afraid she was for her own life and the life of her child, but she also listed all the financial problems that beset them, and in particular Doug Benefield, which would have addressed the unspoken perception and knee-jerk reaction that constantly arises from the perception that Miss Benefield was a gold digger who married somebody who was only going to be able to provide for her. I think it would have been significant for the jurors to hear from Bruce Ferris that this perception of domestic violence and lack of appreciation for it infects our institutions as well as the courts themselves. And I think Bruce Ferris was extremely qualified to provide such testimony, given his background as an active deputy sheriff who worked and specialized in domestic violence and was in court time and time and time again. We had an instance where both parties agreed and the court approved for a cutoff for motions. Despite the fact that we both agreed, we signed a written stipulation, both myself and Ms. O'Donnell and the court. The state still moved for a Daubert hearing after the court suggested it, after the deadline for such motions was closed. The court allowed the state to do it, reopened it. We had the hearing. The court still allowed Bruce Ferris to testify. When the state sought to introduce the video of Douglas Benefield and Miss Benefield and Emerson Benefield and Alicia at the restaurant, upon the defense objection, the court, to the state's surprise, sustained the objection. The state, recognizing how critical that evidence was to their case, looked to the court for help, and it came in a suggestion from the court that perhaps they may try to introduce that evidence under the silent witness theory. Inexplicably, another piece of evidence that was kept from the jury was the DNA evidence. Despite having filed a notice of disclosure of intent to introduce business records declaration, the court prohibited us from introducing the DNA report, which showed that Douglas Benefield's DNA was in fact found on Ashley Benefield's arm and hand, which would have corroborated Miss Benefield's testimony that she initially tried to flee her home, only to have Douglas Benefield grab her, spin her around, put his own back to the door of the home, and refuse to allow her to leave. At trial, the court allowed substantial hearsay to come in through the testimony of Stephanie Murphy. We objected and asked for an instruction. The court agreed that an instruction, a limiting instruction, would be appropriate, yet the court never gave such an instruction. And the reason the court gave for not giving the instruction was that the state and the defense were unable to agree to the language. The court should have fashioned an instruction and given it. The court allowed Detective Christopher Gillum to testify to his various interactions with Miss Benefield, and in particular, Miss Benefield's response. Yet, Your Honor would not allow the defense to call Samara Sweet, who was the Assistant State Attorney for the Manatee County State Attorney's Office, assigned to the case that Detective Gillum testified about, to rebut what Detective Gillum said. Because Samantha Sweet would have said, when she left the office, she fully expected that case, specifically the violation of the South Carolina domestic violence injunction by Douglas Benefield, to be charged. Additionally, the court made some non-evidentiary decisions which we felt had a profound impact on retarding the effectiveness of the defense's case. the court actually quashed the defendant's subpoena to Judge Moreland's judicial assistant and forced the defense to pit Ms. Benefield's former family law attorney against the state's star witness and Doug Benefield's former family law attorney, Stephanie Murphy. We have a Sixth Amendment absolute constitutional right to compel the attendance of witnesses. On behalf of Ms. Benefield, using my judgment and my experience, I felt that Judge Moreland's JA had no dog in this fight. There was no one that would have been more credible to explain to the jurors that the state's theory, the entire theory of prosecution, that Ashley Benefield killed Douglas Benefield because the Broder report was scheduled to be released, was absolutely false, because the JA would have testified that that report was not set for release. There was no date that had been given for that release. Somehow, the court decided that we, the defense, could establish that through a different witness rather than the JA. Respectfully, that is not Your Honor's decision. That was my decision, and it should have been honored, because as I stand here today, I felt and still feel that that would have been the most persuasive evidence to show the jury that Stephanie Murphy's testimony was not worthy of belief. The court allowed, in closing argument, the state to allege that Doug Benefield filed for sole custody of Eva Benefield on May 4th. And that's just factually inaccurate. The fact of the matter was it was Ashley Benefield who filed for sole custody of Eva Benefield. Yet, our objection was overruled.
During closing?
Sir?
During closing? You
Yes.
objected during closing?
Yes. Additionally,
Excuse me? Can you point to me in the transcript where that is?
I'm not prepared to do that now, but as the court knows, the transcript is readily available. What the court did do, however, was, despite the state arguing that Doug Benefield was not facing Ashley Benefield at the time of the shooting, even though that was what their own medical examiner testified to, when I characterize the state's argument as ridiculous, the court felt that was sufficient to sustain an objection. The problem I had with that, and still do, is that one, the court is determining what witnesses are most effective for the defense, and two, the court is precluding me, on behalf of my client, from sharing with the jurors my perception of the state's theory of prosecution. Additionally, and this was over the strenuous objection of the defense,
During closing?
this was now during deliberations.
Okay, all right.
The jurors came back with their first question, asking specifically whether Dr. Jason Quintal reached the conclusions about Doug Benefield himself, or whether or not that was something, the characterization was something in the materials that Dr. Quintal had read. At that point, I thought it was pretty easily addressed by simply having Dr. Quintal's testimony read back to the jurors. Because make no mistake, I asked Dr. Quintal, and Dr. Quintal stated that he concluded his diagnosis of Doug Benefield was that he was, quote, super controlling, a real alpha male, as in don't even look at her, she's mine. And to my surprise, the court would not allow a readback of Dr. Quintal's testimony. Now at that point, we can only speculate as to what the divisions were during the deliberations. But what we do know is that the jurors wanted to know, was this an independent diagnosis that this expert in trauma had reached on his own or not? The court deprived us of that opportunity by not telling the jurors that they were entitled to a readback if they wanted it. That's all I asked, is that the court tell them, if you have questions, we can have Dr. Quintal's testimony read back to you. The court refused to do so. When the jurors came in and announced at 10:30 p.m. that they were home, we begged Your Honor to send them home for the evening. There was no reason to keep them. There was nothing pending that.
No, you didn't. Oh my word, is he like gaslighting us? It was Mr. Taylor said, tell them to go back in there, keep working on it. Huh? That's what I remember. Mr. Taylor was the one that said, they better get back in there and you keep working on that verdict. Yeah, and then?
That required a verdict that night. The court refused. The jurors had been there more than 12 hours. Respectfully, again, the defense felt that it was the court's intent to drive a result that evening, and it was accomplished at Ms. Benefield's expense. So, to sum up, Your Honor, and to close, I can only tell the court that it was a very heated trial. I think the court, for whatever reasons, made an initial judgment and never changed its position. And as a result, our efforts were not what they could have been, and in particular, that we believe would have influenced the outcome, especially because there was not a conviction for the charged offense. The jurors obviously thought something happened in that house on that day. Something occurred in the past that affected Ms. Benefield's judgment. What they did conclude, which we're forced to respect at this point, is that the judgment that Ashley Benefield exercised on that day was faulty, and she did not have to shoot him. But make no mistake, they acquitted her of murder. So what we're left with is a woman who all her life has not the slightest blemish of being anything other than a good citizen, and who, in the court's own words, had the system fail her. She constantly made report after report to the authorities, who never took any action. You can't help but wonder what would have been the outcome of these events had Doug Benefield been charged with a violation of the South Carolina restraining order. Would they have ended up in this position? I also don't think the court can discount the acts of domestic violence, the independent acts, the acts that are established by Doug Benefield's own admissions, and in particular, the justification that he gives for those acts. So, if you conclude that Ms. Benefield was subject to abuse by Doug Benefield, then that has to affect the sentencing that the court imposes. If you conclude that she was not affected by the prior acts, the trustworthiness of which is hard to dispute given his own admissions, then I think the court turns a blind eye to independent evidence establishing that he was abusive. We know the one thing that Dr. Broder did get right was he spoke and concluded about what a wonderful mother Ashley Benefield was. I think it would be beyond dispute to say that this was an unusual act, an aberration from a woman who has no past whatsoever. There's nothing that can replace the loss of Doug Benefield's life. There's nothing that anyone's going to say to the Benefield family that's going to make them feel any better than they feel now. What I can only remind the court is that the independent evidence, from Doug Benefield's side, the family thinks only the best. From Ashley Benefield's side, all the supporters think only the worst. We're compelled to look to the independent perception of Doug Benefield. And even were the court to discount Dr. Russell's testimony, that still leaves Bruce Ferris and Dr. Quintal. And that testimony establishes that Doug Benefield had a deep-seated issue with abuse. It doesn't mean that the family didn't love him, but he would not be the first person that loved ones don't recognize has an issue. And if Ms. Benefield was subjected to abuse, then that's something that Your Honor must take into account in applying an equitable sentence. I hope the court is strong enough to do just that. Thank you.
All right, before I go to the state, I do have a couple of questions. Sir, in your memo, this is regarding downward departure bases. I'm starting with statutory.
Yes.
Under 921.0026 subsection 2.
Yes.
In your written documents and today, you focused on F, victim was initiator, willing participant, aggressor, or provoker of the incident, and G, defendant acted under extreme duress or under the domination of another person. However, you also elicited testimony from Dr. Russell today regarding her diagnosis of Ms. Benefield with PTSD, explaining the genesis of that and how it could affect her. Are you seeking a downward departure under D as well?
It was not my intention to seek any other basis other than what was included in my written sentencing memoranda, but as the court knows, that was filed in advance because I had another trial out of town that I had to attend to. If the court wants to accept that as a potential basis, as well as aberrant act, that's fine. We would be quite content. Either way, our objective is that a downward departure would be appropriate. As the court knows, it comes in the form of two questions. One, is it legally available? And two, is the sound discretion of Your Honor, should you? That's up to the court. I believe we've presented the court with sufficient evidence for all four bases, but my written memoranda only includes two.
All right, well, now, which one's the fourth?
The fourth would be aberrant incident, aberrant behavior.
Oh, isolated incident under J? All right, so, and the reason I ask is it's not uncommon during a sentencing hearing for me to hear testimony or evidence presented by the defense that is intended for mitigation, but actually goes to one of the downward departures. That's why I want to clarify.
Yes, thank you.
All right, that's for the statutory bases, D, F, G, and J. There's also non-statutory bases. In reading your downward departure, your sentencing memo, and today, you've spent a number of pages in the memo, and then a significant time today of your argument on individual and cumulative errors at the trial court level.
Yes, sir.
Are you intending that to be considered as a non-statutory basis for a downward departure?
I can't speak for Your Honor. I can only serve up what I believe contributed to us having a less than effective defense to these charges.
How does that affect the sentencing for today?
To the extent that the court felt that those incidents, and I say incidents rather than errors because that remains to be determined, and I respect the fact that we have a good faith dispute as to those incidents. But if the court decides that those incidents run, those rulings run to the court taking into account, well, maybe I did hold the reins a little too tight, and maybe as a result, the defense wasn't as effective as it could be, because after all, the court sits as the seventh juror. If you feel, knowing what some of the evidence was that did not make it to the panel for their consideration, yes, you would be entitled to embrace that as a basis for departure. And if the court chose to do that, we would be grateful.
All right. That's what I wanted to know. It'll be, say, footnote or parenthetically, certainly if someone can't suffer the slings and arrows and take the criticism, they certainly shouldn't be sitting in this seat. You have absolutely every right to disagree and appeal, and that's what I expect. It's part of the process. My question is this, then. In my years, in researching and dealing with downward departures, I am not familiar with, I haven't seen any support, obviously because non-statutory bases are coming up through the common law, through court decisions where those matters have been recognized. The statute leaves it wide open, right? Any other bases that the court believes. So that's where we have the this non-statutory downward departure bases. I am not familiar with individual or cumulative errors by the trial court being used or cited as a basis for a downward departure. So that's where I was ultimately going with all that. If it's intended to be a non-statutory downward departure, is there any support in the case law for that?
I'm not aware of that specifically in and of itself, but I will parse, if the court will, the substance of what I've had to say. And for example, as it relates to the first basis of departure, the victim's conduct, the court can well take into account the admissions that were made by Douglas Benefield in the deposition. The court can well take into account Ms. Benefield's letter that she left for Douglas Benefield. We may argue and dispute whether or not those two things should have been considered by the panel, but that does not preclude Your Honor from embracing them and reaching a determination for a downward departure.
Understood. All right, the next one was specific to G. I understand arguments and bases for D. I understand and appreciate your arguments for F. G, however, G is acted under extreme duress or under the domination of another person. and I'm just going to phrase it as walking around knowledge of that statutory basis is it's generally a confederate or a co-conspirator or a principal to the offense, as opposed to that basis being used for the victim. The victim is the one that was causing the duress. That's where I think F comes in. The victim's the initiator, the aggressor. So do you have any case law or any law for me that G can also apply, the duress portion can be applied from the victim in the matter as opposed to a confederate, co-conspirator, or principal?
Yes, I don't have a case at hand for the court, but the distinction I will make for the court is let's not be too narrow and interpret that only as it relates to the incident itself. The point I tried to make through the testimony of Dr. Russell was that Ms. Benefield's state of mind on that day, given the prior history of domestic abuse, when in the company of Douglas Benefield, already created in her, because of this past trauma, extreme duress. And I understand the court's distinction, but I do not believe that there is any case law that says that the duress is limited to the moment of the act. I believe the duress can be present from prior occasions, and that was the point I wanted to establish for Your Honor.
All right. Final question. You had mentioned about Dr., and this was both in your memo and in your statements today, Dr. Broder's testimony where, I don't know what the best word is, I'll say walked back his testimony from the stand your ground hearing.
Yes, sir.
I'll just characterize it that way.
Fine.
And you talk about, so we had the stand your ground hearing. It was my understanding from the reading, because he wasn't impeached with any deposition testimony at the stand your ground hearing. The deposition you're talking about happened after the stand your ground hearing.
Correct.
Okay, all right. That was all my questions. Did you have any further statements you want to make in response to the questions I've asked?
No, other than, even though the deposition of Dr. Broder occurred after the testimony, it doesn't lessen what we perceive was the court's linchpin for the stand your ground order, which was tied to, at best, a mistaken statement, and at worst, a false statement to mislead the court.
I understand. Thank you. All right, State.
Judge, I'm not going to address the alleged errors and things that happened during the trial. I believe that's not appropriate for the sentencing. While I do disagree heavily with most of what he said about those issues, I'm not going to address them independently. I do want to address some of the things that the defense said about what knowledge we have of the situation. So the defense kept saying the word independent evidence over and over and over, and that the court should look to the independent evidence of Douglas Benefield's behavior to support some of these downward departure reasons. However, I have arguments about some of those things that the defense said. For instance, the defense wants you to look at Doug Benefield's deposition testimony that was not allowed to come in to the trial. And we all know that there were reasons that was not allowed to come in the trial. It was following the rules of evidence. However, I can represent to the court that at least one of the things that Mr. Taylor said is completely inaccurate, that Doug Benefield, while he admitted to firing the gun, he never said he did it to intimidate her. So I would just ask that we be cautious about what we are presenting as fact when it is not necessarily fact. The defense also said that Doug Benefield violated the South Carolina injunction. That is also one thing that was never established definitively one way or another, whether he violated it. The defense said that Doug Benefield was caught by a neighbor spying into the house. There are differences of opinions as to that, and I think we went through that in trial, that it was just supposition and someone being identified by a voice after the defendant played a voice recording for her. So that's in dispute, whether he was actually there or not. So to take all of these things as factual and allow them to be used in such a way to say that he was a willing participant in this set of behaviors, I would argue is inaccurate. The defense also said that Dr. Quintal said that Doug Benefield was super controlling and an alpha male, but if the court recalls from trial in cross-examination, I asked him, is this opinion based on, at least in part, based on what Ashley Benefield is telling you? And he said yes. So it wasn't that it was his own independent evaluation of Doug Benefield. He was taking what this defendant was saying to him and incorporating that into his opinion. The defense also said that Dr. Ferris said that Doug was a classic abuser. The court, in the state's opinion, correctly ruled that that was inappropriate opinion testimony and was not allowed in front of the jury. And again, there are all kinds of reasons why that's not appropriate evidence to be considered by the jury. And I would say it's inappropriate for the court to consider that as fact in a sentencing. So what we do end up having is bits and pieces of a rocky marriage that in the state's argument do not rise to prior acts of domestic violence. Doug Benefield had problems. He lost his temper sometimes. So did the defendant. They had arguments. It was a marriage, and that happens in marriage. The victim, was never an abusive husband the way the defense keeps trying to represent. That is a fictitious idea that Ashley Benefield has put forth and guided through this entire process. And Dr. Russell even said today and acknowledged that she knew that Ashley Benefield had been diagnosed with histrionic personality disorder, and that one of the symptoms of histrionic personality disorder is that you tend to exaggerate and blow things out of proportion. And that is the state's entire theory, is that this particular defendant just blows things out of proportion and makes things into something that never existed. So the court should consider that in trying to determine whether this victim somehow played into this whole incident that happened the night of the shooting. One of the other things that I will mention from what the defense was alleging was improper rulings by the court, I do want to say in isolation just this one thing. The DNA report, the defense was saying that it would have shown that Doug Benefield's DNA was on Ashley Benefield's arm, and I believe that's a false statement. It would have shown that there was some DNA on her that could have been Doug Benefield's DNA, but it also could have been a family member. And the child, that was a toddler at the time, was clearly a family member. So to imply that the DNA report would have clearly shown that Doug Benefield was holding her and at the time that this incident was going on, I believe is not an accurate statement. So as far as the defendant being a willing participant, the victim being a willing participant, we do only have Ashley Benefield's version of events for that night. That's all we have. And I know the defense in the motion or in the memorandum has mentioned that the court should take what she says as truth, that it's uncontroverted and unimpeached. But I have a case here, Judge, it's Early versus State, 223 Southern 3rd, 1023, which is a First District Court of Appeal case from 2017. And while this talks about a jury, it does give guidance as to the type of situation that we have here. Even when there is no other witness to the events besides the defendant, a jury is not required to accept the defendant's testimony in support of his self-defense theory as true. Instead, it must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. So I believe that the court can wholeheartedly believe what Ashley Benefield said on the stand, or the court is allowed to disbelieve everything she said on the stand. And if that is the basis for this downward departure request, that he was a willing participant or an instigator. The entire evidence that we have of that comes from Ashley Benefield herself. And the state argues that her credibility is below, much below where it should be, and that it is obvious this was a pattern of behavior, that she had a goal to raise this child by herself and to get Doug Benefield out of their lives, and this was the culmination of that pattern. And so her credibility is lower than it should be. The other downward departure reasons that the defense mentioned, the one was the PTSD. But if the court looks at that downward departure reason, it says that that the defendant has a mental disability or problem that requires specialized treatment. And the defense has put on nothing to say that she needs specialized treatment for this, even if the court accepts that she does have PTSD. So the defense has not satisfied their burden for that. As far as isolated, the offense was committed in an unsophisticated manner, isolated incident for which the defendant has shown remorse. I would argue that does not apply. Obviously, this was not a one-time thing. This was a pattern of conduct over a very long period of time. Additionally, it's not unsophisticated. It's a culmination of a pattern. And if the court looks at the facts that came out in trial, that there were multiple firearms placed around the house, the daughter and mother were out of the house conveniently at the time when all of this happened, and this defendant is the only one still alive that has the correct, what she's trying to say is the correct version of events. So I would argue that that downward departure reason does not apply. Or in this.
Just letting you know, we're almost there. It's almost time for sentencing, okay? I think it's already happened in real time. Please don't come in here and give us spoilers. I don't know why people do that. Why do people do that? Do they think they're being helpful? Just ruined it for everyone. So we're almost there. It looks like we're 20 minutes or so behind, and that's, yeah, I mean, it could even be less. So obviously the state's giving their final arguments about this downward departure, which we went over the meaning of that earlier. I can ask Uncle Google again if you want, but just look up downward departure, just to, let me look it up for you, hold on. Downward departure, Florida. Okay, a downward departure sentence allows a judge to impose a sentence that is less than what Florida law requires in some circumstances. So Ashley Benefield's facing a minimum of 11.5 years and up to 30 years. So let's see.
Defense has not met their burden. And Judge, I think it's very difficult when this entire trial has been about pretty much demonizing Doug Benefield and making this defendant the victim, when in fact it was the opposite. Doug Benefield did nothing but try to love this woman and try to love this child and try to do the best by them. And at every turn, she abused him, in my opinion. She tried to withhold this child. She tried to get him in trouble at every turn. She tried to do everything to undermine any relationship that they would have. And he continued to go back, which was probably his one fault, was that he continued to go back and he continued to think that he could make this work. And this defendant took advantage of that. And then when she can't get relief from anywhere else, shoots and kills him. And she got exactly what she wanted for a time. And for that, Judge, we would ask that you sentence her to the maximum 30 years.
Thank you. Rebuttal.
I'm going to speed that up.
All right.
Oh, he's good. Okay.
Okay, so at this point, I've heard all the evidence. I've heard the arguments of counsel. Ms. Benefield, this is addressed to you. Please feel free to consult with your attorneys before you answer, or if you want to answer. But at this point, I always just check with the defendant and say, okay, I've heard. Of course, there was a stack of letters that I got from your attorney as part of the downward departure. Heard Dr. Russell's testimony today, of course, presided over the entire trial, heard the statements from the state as well. I always ask, though, is there anybody that I haven't heard from, any testimony I didn't hear, any evidence that I didn't hear, anything at all that I need to know to make a fair decision in this matter?
Your Honor, Ms. Benefield feels that I've spoken for her.
Excellent, all right. I also give a final statement, and I'm sure that you and your attorneys have talked about this at length. You are absolutely not required to make any statement. However, I also, whenever I have a trial case, we're doing sentencing, if it's an open plea, I do always give the defendant the last opportunity if there's any statements that you want to make. You're absolutely not required to. I'm sure you've already talked to your attorneys about it. But if there's any statement you want to make, please feel free to do so. If not, we'll just move on with sentencing.
I know the court won't interpret her choosing not to as a lack of invitation and remorse.
Fair enough. And as I said, you're not required to at all. All right, is there any legal reason why sentence cannot be imposed?
No, sir.
She really has no reaction, none today. She's just like, obviously they spoke about it before the time. Like, she's not going to say a word.
All right, so the first thing we need to do is talk about the bases that have been argued for downward departure. And I think today it's an absolute tragedy that we're even here today. And I often, in these situations, sit back and wonder, how did we get here? How did life bring us to this point, not only here in court, but between the Benefields? I think both sides have acknowledged, because both the defense, Mr. Taylor, and the state talked about lenses and perspectives. And I think this is a good example of exactly that, where whatever lens you view this case from can really affect how you view the players, the results, the participants, and the outcome. So we've got the score sheet to start from. The issue is whether a downward departure has been sufficiently, the burden of proving that has been sufficiently met, and then whether the court would grant a downward departure. So the bases are, and I'm going to just take them in alphabetical order from the statute, 921.0026 subsection 2. The first one is D. The defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, or for a physical disability, and the defendant is amenable to treatment. In that particular one, there was the testimony by Dr. Russell that she has diagnosed the defendant with PTSD. It's a complex trauma. She explained the genesis of it and how she reached that conclusion. But importantly, what needs to flow from that is a description of what that specialized treatment is, what sort of treatment is important or would be necessary to treat that PTSD, inpatient, outpatient, what kind of mental health therapies, and so forth. So based upon the competent and substantial evidence that has been presented, I do not find that D has been proven by preponderance of the evidence, all the elements of D. F, the victim was an initiator, willing participant, aggressor, or provoker of the incident. The reason I asked that question, and I was looking around, is I had a case, and I thought I put it in my packet for today, but I'm not seeing it. There was actually a decision in the Florida Law Weekly within the past couple of months, it hasn't been too long ago, where that very issue was discussed. And the DCA in that case actually came down and said, when it talks about the incident, the evidence must support that the victim was an initiator, willing participant, aggressor, or provoker of the incident. And specifically said the court should not consider all of the pre-existing or attendant circumstances and just look at that incident. I think both sides took a great amount of time throughout this case to talk about incidents and events and happenings that occurred before September 27th of 2020. Do I have the date right? September 27th of 2020? But I think the case law talks about that particular day or that particular event. And it doesn't need to be, for this downward departure basis, the law is very clear. The defense doesn't have to prove it by clear and convincing evidence beyond a reasonable doubt. They don't have to prove or provide evidence that is beyond a reasonable doubt. The question is there competent and substantial evidence that in the incident itself, the victim was an initiator, willing participant, aggressor, or provoker of the incident? And quite frankly, the evidence, the preponderance of the evidence has established that Ms. Benefield's testimony is sufficient in and of itself, and I understand the state is arguing that to discount her credibility, but is there evidence in the record that proves by a preponderance that Doug Benefield was an initiator, willing participant, aggressor, or provoker of the incident? And there is. That was the entire basis of the self-defense argument. So I do find that the requirements of F have been met. G, the defendant acted under extreme duress or under the domination of another person. This is why I was asking about the case law, because I have not seen this particular statutory basis applied in this particular factual scenario where it's argued that the defendant acted under the extreme duress of the victim as a self-defense matter. But just because I haven't seen the case law doesn't mean that it doesn't exist and it can't be argued for those or that purpose. So for the purposes of today, using a similar analysis as I did under F, but also considering the past relationship between the parties, I think there has been competent, substantial evidence to establish by a preponderance that the defendant acted under extreme duress. The domination of another person, I just don't think fits. So to the extent that that particular downward departure basis requires that the duress comes from a conspirator, a co-conspirator, a confederate, or a principal, I could be wrong, but I think it applies, and I'm applying it here. Or I think it's been proven. And then J was the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. The case that I talked about a few minutes ago regarding victim was an initiator, willing participant, aggressor, or provoker of the incident, J has similar language. The offense was committed in a sophisticated manner. So I understand the state's argument saying, hey, this was a whole series of events and was very sophisticated in its planning and execution. At the end of the day, the statute itself says the offense was committed in an unsophisticated manner, isolated incident for which the defendant has shown remorse. So if I look at just the incident itself, there's nothing sophisticated necessarily about self-defense and using self-defense. Isolated incident, the defense has pointed out, and the score sheet shows there are no prior acts of violence, there's no prior convictions. The case law requires, though, that all three elements of this be established. The final one is the defendant has shown remorse. Obviously, she's exercised a very, very fundamental constitutional right by not making a statement today. But I can also, I believe, consider the testimony that was provided during the trial. And remorse is not necessarily and doesn't have to be, I'm sorry I did this. because someone is perfectly entitled to maintain their innocence even in light of a verdict of guilty by a jury. So I find that during the trial itself, that Ms. Benefield did demonstrate remorse for this entire incident happening and the culmination and the resulting death of Mr. Benefield. So I do find that J has been established. The non-statutory bases, there were none explicitly argued, but I'm going to make a ruling on the individual and culmination of errors for appellate purposes. Again, I'm not aware of any case law that establishes that. To the extent that there's an argument to be made that, and when I say individual errors, I'm talking about fundamental error, right? Because that could just be one thing and fundamentally vitiates the fairness of the entire trial. So individual or cumulative errors being the bases of a downward departure, I'm going to go ahead and make the finding that those are not, errors by the trial court are not bases for a downward departure, non-statutory bases. I may be wrong. We'll find out. The second part of the analysis is whether the court is going to exercise its discretion to depart. And that's where you really take into consideration those factors in determining, in light of all of the facts and evidence that have been presented, if this is a case that the court believes a downward departure should be granted. And as I said, I understand completely that two sides of this room are viewing this same case through very different lenses. As I consider all of the evidence that I talked about earlier that I reviewed in preparing for today, the jury's verdict, which they did not find Ms. Benefield guilty of the charged offense. It was a lesser included offense that did not include depraved mind. It included doing an act which resulted in the death of another person. I consider the score sheet and what Florida statute or chapter 921 discusses regarding the aim of sentencing, that being the primary purpose of sentencing is to punish, the secondary purpose is to rehabilitate. The PSI, which has been reviewed and considered, and I understand throughout the arguments that the defense has raised their disagreements. For what it's worth, the PSI in the factual part really just recreates or retypes the complaint affidavit. I don't really put a lot of weight on that. I don't need that because I presided over the entire trial. So I don't put a lot of weight on the factual recitation that was in the PSI. And as we all know,
Quick pause. I'm really enjoying all your spicy comments today. You guys are so snarky. Oh my goodness. I'm just looking at this chat like, whoa. Just remember, it's healthy to disagree sometimes. I don't get why people think we have to agree at all times. Okay, we're not a cult. We're just adults watching a trial together. This is now the sentencing. And if you disagree or agree with the judge or whatever, express it. It's healthy, right? So, we're getting to that sentencing. And please don't spoil it for everyone. We're waiting to hear the sentence together for the first time. So here we go.
the PSI is not controlling on the court. The probation officer who does the report makes a recommendation, but unlike in juvenile court, where the Department of Juvenile Justice's recommendation is somewhat binding on the court, the DOC recommendation is not, but I did review that. And of course, as I said, I reviewed the defendant's sentencing memorandum, all of the various attachments, and listened to the statements that were made today from Dr. Russell, as well as David, Wes, Tommy, and Eva Benefield, And all I can say is thank you to everyone who took the time to write a letter and share your experiences. A number of them talked about growing up with Ms. Benefield, their interactions with her as they've grown up and growing into adulthood. Thank you for the statements regarding your relationships with Douglas Benefield and how his loss has impacted each of you. So when I look at the bases for the downward departure and I consider all of the facts and evidence that have been presented to me, my ultimate conclusion, Ms. Benefield, is that this is not a downward departure case. So with that said, the sentence of the court will be as follows.
Whoa, whoa, whoa. Let's just wait for it for a second. So it's not stand your ground. It's not downward departure. Okay, okay. So here we go. Buckle up. It's sentencing time. Oh, my word. Sure, here we go.
I'm going to sentence you to 20 years in Florida State Prison. That's to be followed by 10 years of probation. Upon your release, and the Florida State Prison was, of course, with all credit for time served, you must initially report to the Bradenton Department of Corrections. We'll be able to provide you a map of where that is. Cost of supervision will be a condition of supervision. Based upon the testimony of Dr. Russell today regarding you suffering from and being diagnosed with PTSD, the court is going to order as a condition of your probation that you obtain a mental health evaluation at your expense within 60 days of beginning your probation. You're to complete any recommended treatment, including residential treatment and aftercare if it's recommended, on the first attempt at your expense. You're to provide proof to your probation officer regarding the evaluation, participation in, and completion of that treatment. If it's necessary for your probation officer, you'll need to sign any waivers or releases that are necessary for them to get the information that they need or speak with your evaluators and treaters. I am going to order the forfeiture of the firearm in this matter, that being the Springfield .45, and I'm ordering that you have given up all rights, title, and interest to the same. I haven't heard anything about restitution at this point. I am going to order restitution. I'll reserve jurisdiction to determine the amount of restitution, the payee or payees, the payment schedule, if any, and other terms and conditions of restitution. I'm also going to reserve jurisdiction on the restitution to determine whether or not to waive or reduce the monthly cost of supervision and or the fees and surcharges that are associated. I'm going to impose the following monetary obligations: the felony adjudication of guilt court costs, $100 cost of prosecution.
200.
Do you have an affidavit?
I don't have it with me.
I can look.
If you need one, we can get one.
It's required by Florida law.
Just, there's,
If you want to
3,000
continue on,
page.
we'll try and find it.
All right. If an affidavit is for cost of investigation is presented, I'll order $200 to the Marietta County Sheriff's Office. For now, I'm going to make all the legal financial obligations a condition of probation. All right, State, now that you've seen where I'm at with the sentencing, was there anything that you want to do, any further arguments, anything else you want me to consider?
Judge, my only concern would be the mental health evaluation. I would prefer that it not be with Barbara Russell when she's on probation and has to do the mental evaluation.
You don't want what?
You have ordered that the defendant do a mental health evaluation when she gets out on
Correct.
probation, and I would request that it be someone other than any of the doctors that were involved in this case. So not Barbara Russell or Dr. Quintal or Dr. Broder. Those-
Okay. I'm not going to order that. I'll let
He did the snarky neck. I like this judge's snarky neck. Okay. Well, yeah. Otherwise, she's going to move in with him. Oh, my word.
you pick your mental health professional that you want to see and consult with. Sir, now that I've told you where I'm at, was there anything that I need to explain or clarify?
No, sir. If you would, how long is the period of probation?
It was 10 years. Okay, Ms. Benefield, you have 30 days to appeal the judgment and sentence of, oh, yes, sir.
Make one statement for the record. I object for the record and argue it's an abuse of discretion based on the undisputed facts, not the granted downward departure.
Oh, yes, sir, absolutely. I think that's generally preserved no matter what, but
I do too, but.
I appreciate your belt.
But the appellate courts like to find not preservation, so I'm overly careful.
I understood. Belt and suspenders, no problem at all. Yes, sir. So, objection to the abuse of discretion for not granting the downward departure. Noted. All right, Ms. Benefield, you have 30 days to appeal the judgment and sentence of the court. If you can't afford to hire a lawyer, one will be appointed to represent you. Go ahead.
Sorry, I'll just have one thing.
Is it regarding appeal?
Regarding,
Appeal?
no.
Oh, well, go ahead then.
I was going to ask the court if the court would make arrangements to ensure that Ms. Benefield remains in Manatee County for at least 14 days, if not 30, so that we can tie up all the loose ends in preparation for the appeal.
Okay. I don't know how much pull I have over that. DOC comes gets people when they come get them.
Can I suggest that Your Honor set this for a report in perhaps 30 days?
All right, why don't you send me an order directing the sheriff to hold her pending any final hearings or matters? And I'll,
Judge, the most specific thing, we're going to be filing a motion for bond pending appeal, so that's why.
keep her there for that.
Yes, so to avoid the necessity of her going back and forth.
Absolutely. So do me a favor, contact Kelly, my JA, get that set. I didn't see it's been filed yet, but get it filed.
It has not, but I will file it tomorrow.
All right, get it filed. Talk with Kelly about getting a hearing date, and then I'll sign an order to hold her until after that date. Absolutely.
Thank you, Judge.
Thanks.
Of course. Okay, for the appellate purposes, what I was going to say is, ma'am, speak with your attorney. You can hire someone if you want, a private attorney for that. If ultimately you are going to seek the services of the public defender, I'll just need a financial affidavit and a motion to appoint. And then once Mr. Taylor completes all of his obligations as trial counsel, we'll get a local PD appointed and then the 10th Circuit PD. All right, ma'am. Thank you very much.
$20 years. 20-year sentence plus 10 years probation. She's 33 years old now. So, there she goes. She'll be 53 years old by the time she gets out. 63 when she's done with her sentence. Her daughter's now 6 years old, so her daughter will be 26 by the time Ashley gets out. I wonder, is there a press conference or something? Was there one? I know they had one after the verdict. Did they have one after the sentencing? Let's see. I don't see one. Fingerprint time. Oh, shame, Eva. Doesn't look like it. Woody Decent says, can she early parole? Yeah, I'm not sure. Oh, the feed is just going to end right there. So that's the end of the court day. Wow. So what do you think of the sentence? Do you think it's too little? Do you think it's too much? Let me know. Especially let me know in the comments. I can't wait to read all your comments as well, because I miss a lot of them. Even though I'm looking there and I'm seeing what you guys are saying. I think I missed quite a few of them as well during the live stream, because I'm managing all the things. So I can't wait to read all your comments. Please leave that below. Please like and share if you haven't yet, so others can also find this. Especially earlier, people were saying, did I cover the trial? Of course I did. So you got to find the playlist if you didn't see it. It's all defluffed for you, time-stamped, all of that, right? Okay, so Facey McGee says too little, and Linda says too much. And that's, see, people can agree to disagree. It's okay to disagree. So Melissa says too little. Interesting. Psycho Kitty said what? 2 hours of BS chat for 2 minutes of sentence. That's how it goes. Were you there with us yesterday? Whoa, Sarah Boone sentencing. If you didn't see that, got to check it out. Jamie Komorowski. Can you believe Jamie Komorowski is only 5 years younger than Ashley Benefield? Damn. You know, Jamie acts a lot younger. So yeah, we've seen 3 sentencings in the last 24 hours. My goodness. And a press conference in between. Carrie says as lesser included and bit second degree, she got about right to be fair, as was between 10 and 30 years. And she got 20 years plus 10 on license. Yeah. I can't wait to see Eva's TikToks as well to see, you know, what does she think about it. If you haven't followed Eva on TikTok, her handle is Eva the Frickin' Diva. And I'm sure she'll express herself there as well. So, and if she ever does want to come chat here, I know you guys were saying she must come here and chat. If anyone wants to chat to us here at Grizzly True Crime, they can always email me, grizzlytruecrime@gmail.com. All right, everyone, thank you so much for watching this sentencing with me as well. I'm going to make sure that I link the original court feed as well if you want to check out the full feed without any commentary and things like that. And I will see you in the next one. Thank you, mods. I really appreciate it. Also, no one's asked me. I did mention I made a FOIA request and I received a whole bunch of photos in this case. The problem is, as I was going through them again today, because I wanted to show some, I don't know if I could show them. You know, there's a lot of blood. And there's also Ashley Benefield. They were showing her scratches, which is not much, right? It's like a tiny little scratch. But she's like in her underwear. So I don't know if I can show that right now. If there's anything I can show, I'll put it on Patreon. And I'll make it a public post so it's free, okay? So go and check out my Patreon if you want. And I'll put some of them over there. Thank you so much, everyone. I will see you again very soon. Stay safe.